As contractors rush to implement CMMC, one area that's often overlooked is the legal risk of getting it wrong. You don't need a breach to face consequences. Misrepresenting compliance can result in investigations, contract termination, or even million-dollar penalties, as we've already seen in real enforcement cases. To help us navigate this landscape, we're joined by Chelsea Zortman, associate at McDonald Hopkins and a member of the firm's data privacy and cybersecurity practice group. Chelsea has extensive experience in incident response, breach notification, and regulatory investigations. She's seen firsthand how legal missteps can derail even technically strong compliance programs. In her session, part one of a two-part legal-focused series, Chelsea Zortman will break down the legal risk that contractors can't afford to overlook as CMMC takes hold.
Thank you so much for the warm welcome. Hello, everyone. Today's presentation will focus on understanding the legal risks associated with the cybersecurity model certification, better known as CMMC. Whether you're a prime contractor or a subcontractor, the risks are real. They are avoidable with the proper presentation or proper preparation and consideration. So let's go ahead and dive in. Generally, as an overview, we want to know what CMMC is. Why does it matter? Why should you care about CMMC? The Cybersecurity Model Certification, or CMMC, is a framework that was developed by the Department of Defense to protect sensitive but unclassified information. Specifically, we're going to see this labeled as FCI or CUI, referring to federal contract information or controlled unclassified information. This all revolves within the defense ecosystem and supply chain. So these CMMC requirements evolved from existing cybersecurity regulations that are under DFARS 252.204/7012 and FAR Clause 52.204/21. These two clauses had long required defense contractors to implement NIST SP 800-171 security controls and standards. However, that compliance under the model was largely self-policed, and breaches persisted in and out of the DoD supply chain ecosystem. They're continuing to persist today, and they're a grave concern in many areas of business. That brings about the development of CMMC. CMMC enforces third-party validation and creates a maturity-based model to ensure that contractors are truly implementing the cybersecurity controls that are placed upon them. So in late 2021, the DoD released CMMC 2.0. The CMMC 2.0 highlighted a couple of things. It reduced the model from 5 to 3 levels to simplify the adoption across both prime and subcontractors. Level 2.0 also aligned more directly with NIST 800-171 and 800-172, which are those pre-existing security standards and protocols that most contractors should be familiar with already, if not already upholding. 2.0 also introduced self-assessments at level 1 and then at certain level 2 contracts, the more non-prioritized acquisitions. It also reserved third-party assessments via C3PAOs or certified third-party assessor organizations for more sensitive level 2 contracts. 2.0 further eliminated many process-based level 2 and 3 requirements in favor of focusing on actual control implementation. All to say, the bottom line is that CMMC's compliance is a precondition to winning DoD contracts. It's no longer an option. The bottom line is that no certificate, no award, no option. Like I said before, there are 3 main levels of CMMC. Most contractors will fall under levels 1 or 2. Level 3 applies only to the most sensitive programs within the DoD, but level 2 splits between prioritized, so third-party assessments, and then non-prioritized, which would be those self-assessments. There are several key legal risks that are important to understand. They fall under a broad variety of categories. Some of these categories include the False Claims Act exposure. It also falls into potential contract termination for either default or termination for convenience. Some other considerations include the flow down and subcontractor risks. So we're talking about those flow down clauses that go from prime to subcontractors. Some other things that might arise are bid protests, suspension, debarment, and then considerable reputational harm. Taking them in turn, we'll start with the False Claims Act. Under the False Claims Act, the core idea is that the FCA penalizes knowingly false statements that were made to the government, either in connection with payment or contracting. This applies to CMMC because if you certify that you're compliant when you're not compliant, even if it's due to an inaccurate self-assessment, you might be found liable under the FCA. These penalties can include treble damages and fines per false claim. So not as a whole, but per individual false claim, and those can add up considerably. One of the case examples that we turn to quite often is Aerojet Rocketdyne from 2015. So although it's back in 2015, this is one of the catalysts for CMMC and all of these standards being applied across the board. Aerojet allegedly misrepresented its cybersecurity compliance, and they ultimately settled with the FCA for $9 million. The takeaway from this case is that contractors must ensure the internal representations align with actual system security plans, or SSPs, and a plan of action and mitigation, or POA&Ms. And so whatever you're representing on paper and checking the box to actually has to be implemented and played out and aligned with the actual security controls and measures in place within your organization. One of the other legal risks associated with CMMC for contractors is potential contract termination. Likely this will occur within default termination or termination for convenience. So with default termination, this can occur if CMMC non-compliance is discovered post-award. So even if it's not fraudulent, your organization did not intend to knowingly lie and deceive the government, a lack of due diligence and preparation in itself could just result in that loss of business, that loss of contract award. In most cases, this will actually result in termination for convenience. And the DoD can use this instead of bringing a False Claims Act. But it still actually can have a huge impact on past performance evaluations, which we all understand to be a very big and important part of the contract award process. We'll touch on this a bit more later. One of the other considerations and legal risks are subcontractor risks. So in this CMMC model and new world of contracting, prime contractors are responsible for ensuring subcontractors meet CMMC requirements. If a subcontractor fails, the prime could be held liable and will likely be held liable because subcontractors, again, are required under prime contractors to have certain requirements in place. So if there are flow down clauses that are either absent or weak between the prime and the subcontractor, that can raise many legal issues. Most of the time, this occurs when there's unclear subcontractor obligations. So if your subcontractors aren't CMMC compliant, the prime contractor could be liable. And this can even lead to either a competitor filing a protest or a challenge for the award. We often see this occur with small businesses that are really struggling to meet those level 2 requirements, but are still very active in the supply chain and also active in the sense that prime contractors really rely on those smaller businesses within that supply chain ecosystem. One of the things I just mentioned are bid protests. So if a contractor falsely asserts compliance and wins an award, a competitor can file a bid protest. Because a bid protest challenges the award of the contract, this protest filing itself starts a really thorough review process of the award. This often results in either a delay of the business and, in worst cases, a complete loss of the business if the award is then taken away. So ultimately, the GAO or Court of Federal Claims will likely uphold a bid protest challenge if they determine that CMMC compliance was improperly evaluated by the original awardee of that contract. There's also civil and criminal enforcement risks. The DOJ has a civil cyber fraud initiative that was launched in 2021. And this civil cyber fraud initiative aggressively targets misrepresenting cybersecurity posture. So you can be pursued even without a data breach. And this is a common misconception. Usually people think that the cyber fraud initiative will only look into events of security incidents, but it's possible that they will look into your organization even without a data breach, simply for failing to comply or misleading the government. That's enough for an investigation. One of these examples in which there wasn't a security incident, but the investigation occurred from the DOJ anyway, occurred in 2022. There was a managed service provider that ended up having to pay the FCA $293,000 for failing to follow the NIST 800 protocols, and they certified the compliance. So during the award process, they looked at the representations and certifications. They went ahead and checked the box saying that they certified themselves as upholding the standards and security regulations under NIST 800. And it turns out that they actually hadn't implemented those across the organization. So ultimately, this lends itself to the idea that CMMC compliance is not just an IT project, it's a legal exposure point as well. It contains considerable risks for your organization, and it's important that you engage legal compliance and procurement teams to ensure that you're not just secure technically, but you're also legally protected. There are a myriad of contractual traps and government enforcement that can also kind of play into this. Some of this includes what contractual language you include within your contract between prime and subcontractors, as well as that direct contract with the government. The government has audit rights. There are subcontractor flow down obligations that prime contractors need to consider and implement thoroughly. There's also that civil and criminal exposure that we just kind of referenced, and the DOJ and DoD enforcement trends. So we're talking about self-attestation. It's more than a checkbox, right? Under CMMC 2.0, many contractors can self-attest to compliance. There's that level 1 and some level 2 contracts that fall under the self-attestation. The issue with the self-attestation is that it's very similar to pre-CMM 2.0 obligations, where you can just check a box. But the risk there is that self-attestation is a legal representation. So if there's a misstatement made here, it can be used as evidence in either civil or criminal cases. You need to be very careful about the representation that you're making within those self-attestations. That's why it's incredibly important to have counsel review SSPs and attestations prior to submission. You have to treat them like sworn statements. There's additional contract clauses and risk allocation to consider as well. Within the contracts themselves, you're going to want to review for indemnity clauses that might shift the liability between parties. You're going to want to really avoid vague compliance language. Those quotes of "to best of our knowledge," those are often really weak and not protective within the contract itself. So again, this is another area in which you want to work with your legal counsel to actually define what CMMC compliance means. Break it down very, very specifically so that subcontractors understand and your organization itself understands what your obligations are, and to avoid any ambiguity. So the government does retain the right to audit, and they also have the authority to investigate. This means that the DoD and Defense Contract Management Agency, or DCMA, have full audit rights. So you should be prepared to be audited by the government at any time. The government can review your documentation, and if what they find doesn't match what you attested to, it's not just a failed audit, it could be a legal matter, like we've said before. So your SSP, your System Security Plan, your POA and M, your Plan of Action and Milestones, and assessment artifacts, they all must be readily available and accurate for review at any time by the government. The government, like I said, has that right to audit. You need to make sure that those documents, those plans are available to provide to the government when and if they ask for them. False documentation or gaps that are discovered within the audit can be forwarded to the Inspector General or the DOA. So if it takes a long time, if you don't have reasoning within your action and milestones plan for why certain standards are not in place, and you can't provide that evidence to support either a delay in implementation or otherwise, those are going to be key things that the government will hone in on and will ask for follow-up questions on, and could lead to potential legal risks. There's the addition of subcontractor due diligence. So prime contractors, like we've said, can't just assume that subs are compliant. They have that legal responsibility to ensure that the subcontractors are upholding the same standards and regulations that prime contractors are under. So prime contractors really are building in oversight into their contracts. And as a prime contractor, you have to treat it like any other risk within the supply chain. So some things that prime contractors might be doing and should be doing are including those flow down clauses requiring CMMC compliant. Those flow down clauses, like we said before, need to have that clear and precise language, which allows everybody to fully understand what obligations are expected of them. It also requires evidence of assessments or certification from subcontractors. Those are things that prime contractors should ask for from subcontractors. They should be reviewing whatever assessments and certification subcontractors are saying they have in place to ensure that they meet those CMMC requirements as well. Prime contractors will likely also start asking for more and more periodic audits or requests for documentations from subcontractors. And this is because of the heightened legal risk associated with prime contractors bringing on board more and more subcontractors. They're really responsible for the subcontractors' implementation and ensuring that subcontractors are doing what they say they are doing. Again, it's the civil and criminal enforcement landscape. So we talked about this before. CMMC compliance is not just an IT project, it's a legal exposure point. You really need to make sure that you're not setting yourself up for the DOJ to come in and review all of your programs and ensure that you have everything readily accessible to provide to them in the event that there's any additional questions or concerns about the implementation of the standards and regulations that you are required to uphold. So now that we've covered these legal risks, let's talk about how to protect your business. And here are some of the most effective strategies for reducing CMMC related legal exposure. There are abilities to engage legal early in the compliance planning, which will help you mitigate some of the risks associated with the flow down clauses and things like that. You also want to maintain and validate that documentation, like we've been talking about, make sure it's readily accessible and available. You want to make sure you're training across legal, IT, contracts, procurement, widely across the organization. Those flow down CMMC terms, again, go to the subcontractors from the prime contractors. You're going to continually monitor risk. It's not just something that you can do an exercise for once and put it aside. It's a continual and evolving process that you need to maintain and update as you go along. One of the other considerations that you might do is engage cyber liability insurance. It can be an asset to help you reduce your liability. Taking those in turns, engage your legal counsel early. Don't treat this as just an IT or a security task. While there is a strong technical component to being CMMC ready and compliant, your legal team should be involved in the review process. Legal will likely be involved when there's any sort of representations of compliance to the government, right? So you want to make sure that legal is understanding what those representations are and working internally with your technology teams to ensure that those representations are accurate. Legal is also going to want to be involved in subcontractor agreements and flow down terms. They're going to want to know any internal cybersecurity policies and procedures. Again, this all works together to ensure that everything's aligning in the way that you're representing to the government, that it is actually operating within your organization. And if there's not, this gives your internal teams and maybe outside counsel the ability to work together to ensure that things are actually brought back to the security standards and the legal compliance that you are attesting to the government. One of the major reminders in the legal side of things is to remember that if you're signing a self-attestation, you're making a legal representation, and that's why it's so important to involve your legal counsel early on in this process. The second mitigation tactic is to document everything. Accurate and up-to-date documentation is your best evidence of compliance to the government. Maintain your system security plan, maintain your plan of action and milestones, and maintain all relevant training, maintain audit logs and assessment reports. You have the obligation under your contract, any awarded contract with the government, to maintain your audit logs, to maintain different technical measures. Those are outlined within both CMMC 2.0 as well as the NIST 800 protocols and standards. And so you should really be ensuring that your technical team understands that and that your internal technical measures align with those security protocols. Within your organization, another mitigation technique and tactic would be to train and have cross-functional buy-in across your organization. So all of your different departments, your procurement, your contract department, your legal teams, they need to understand their roles within this process. They need to fully understand what parts they're owning and what parts they're helping implement across the organization. So within solicitations and responses, you need to ensure that you're accurately reflecting your cyber status. You need to include proper flow down language again and avoid vague or overly optimistic statements. Again, this is just saying that if you don't have a certain standard or technique in place, you need to be forthright and upfront with both prime contractors and the government that you're still working on implementing that technique, that you have a plan in place. Here's a documentation, our mitigation plan, and here's how we're going to make sure we accomplish this by a certain due date. Everyone needs to know what the implications of overpromising cyber readiness is to the government. Like we've been talking about, those implications can range from both civil and criminal penalties, as well as just loss of business, reputational harm, all of those things. So it's a very serious thing, and overstating and over-certifying things to the government can land you in hot water. The fourth mitigation technique and tactic would be subcontractor oversight. Particularly for prime contractors, again, you're responsible for your supply chain. So if a subcontractor fails to comply, as a prime contractor, you could be held accountable. The best practices here would be in requiring subcontractors to provide evidence of their compliance. All of these SSPs and self-attestations that we've been talking about, it's good to review those and fully understand what your subcontractors attesting to. This includes making sure that you have audit rights baked into your contracts with subcontractors. So there should be a clause that provides a prime contractor the right and ability to audit subcontractors. If you're using templates, make sure that they are the appropriate ones that include the flow down, CMMC, and DFARS terms clearly. One method of doing this is just including the DFARS and CMMC terms on their face. One of the issues and risks with just simply writing the CMMC 2.0 or DFARS clause that it relates back to is that it doesn't clearly outline the obligations and responsibilities within those clauses themselves. So it's important that within the negotiation process or within the contract drafting process, that both the prime contractor and the subcontractor have the same clear, unambiguous interpretation of what those clauses represent and what those obligations truly are. The fifth mitigation technique and tactic is to treat CMMC as a living compliance regime. Again, compliance isn't one and done. It's a continuous effort that you need to maintain throughout the life cycle of your contracts. You need to implement and review calendar and periodic self-assessment within your own organization. And it's imperative that you use vulnerability scanning, monitoring tools that not only protect your organization across best industry standards, but align with those NIST 800, 171, and CMMC control set protocols. The other consideration is cyber liability insurance. If you consider purchasing cyber liability insurance, you need to ensure that it covers both regulatory defense and fines, third-party claims like a subcontractor breach, and breach response costs tied to federal data. You want to consult legal on this one for sure to confirm that your insurance matches the CMMC exposure profile. And contractors who do not treat CMMC as a compliance checkbox reduce that exposure risk. Those that are considering cyber liability insurance, as well as these other mitigation techniques, treated as a legal and operational risk, are the ones that are best positioned for long-term success within the DoD ecosystem and award process. Some final thoughts are that companies must just navigate the interplay between CMMC certifications and other federal cybersecurity frameworks, like NIST 800, 171, which really underpins the CMMC practices. Non-alignment between certifications and actual cybersecurity posture can open avenues for government investigators to claim intentional deception by contractors against the government. Moreover, when companies anticipate evolving regulatory interpretations, courts and agencies are actively shaping these contours of compliance and materiality through enforcement actions. And all of that to say is that you need to be in charge, you need to be upfront, you need to be in a timely manner understanding how these compliance mechanisms are evolving and changing and developing over time to ensure that your standards that you're implementing within your organization are aligning with the most up-to-date controls and process. This is best done when you engage legal counsel as well as third parties such as CyberSheath to ensure that your technical and legal obligations are aligned and up to date. You establish a dynamic compliance monitoring program that you can integrate both real-time risks and assessment by reviewing your audit findings, using cyber threat intelligence, maintaining a defensible position in any potential litigation or government inquiry. The goal here is not perfection, it's accountability and diligence. That's what the federal government is wanting contractors to uphold, to fully understand what your obligations are, to ensure that you're providing best practices for technical security measures as well as legal compliance. So as CMMC evolves, your compliance strategy should also evolve. With that said, I just want to thank you all so much for your time today. Please don't hesitate to reach out with any questions. Again, thank you so much.
Thank you, Chelsea, for that critical insight into the legal risks contractors face under CMMC. Understanding these pitfalls is just as important as implementing technical controls, and your guidance will help organizations avoid these scenarios. Tomorrow, we'll continue this series with practical strategies to stay compliant and avoid costly missteps like misrepresenting your controls, missing reporting requirements, or leaving contract obligations unmet.